This is a second video about freezing injunctions. Goes through the first video, sets out some basic information. This second video is about what you will actually need to show the court if you are to obtain a freezing order, a freezing injunction. First thing to think about is you have to move fast. If you've got evidence that the other side in the dispute are moving their assets, dissipating their assets, not only do you have to move fast to stop that dissipation, you also have to move fast to convince the court that you are acting in a bona fide manner and that you should be granted a freezing order. If you delay looking for a freezing order, the court may well hold it against you. Anyway, let's presume that you have acted quickly within the few working days of finding good cause to go for a freezing order. What will the court be looking for? It'll be looking for three things. First thing is that the court has jurisdiction, that there are assets within the jurisdiction of the court, and we'll talk more about that later on. It'll also be looking for a real risk, open speech marks, real risk, closed speech marks, that assets will be dissipated. And we'll also talk later on about what a real risk looks like. Third thing, the court will want to see that the greater claim that you have against your opponent is a good and arguable claim. And again, we'll talk about that in more detail. So back to the first point, jurisdiction. It's pretty simple. Are the assets of the person that you want to freeze, are they in England and Wales? Great, no problem. You can have a freezing order. Well, you've passed the first test to get a freezing order based in England and Wales, meaning those assets are frozen. Can you get a worldwide freezing order? Yes, you can, but let me tell you, it's really quite difficult. And of course, you have to have evidence of the assets that people hold. You can't just go for a general worldwide order. You need to be very specific about what it is that you're trying to freeze. And you need to pass all the other tests as well. Let me tell you, worldwide freezing orders are quite hard to come by. Second test is a real risk of dissipation of assets. So real risk, it's an English phrase. What does it mean? What do the courts think it means? Well, more than just a chance. Most claimants out there, when they bring a case against somebody, they're worried that the defendant is going to try and hide the assets from them. With good cause, I think. I represented somebody who was trying to sue their business partner, and the business partner transferred his share of a house to his wife. That house was then sold. His wife was a US citizen, so the proceeds of the house were moved out of England and moved to the US, and my client's opponent chose to go bankrupt. Extreme measures. It meant that my client was relying on the trustee in bankruptcy to recover the tens of thousands of pounds that she was owed in the judgment she had against him. So what does real risk mean? Well, there's a case. It's called Les Ambassadeurs Club Limited versus Mr. U. Les Ambassadeurs, I understand, is a gambling club in Mayfair. Mr. U was a gambler, and unbelievably to me, Mr. U ran up debts based on cheques given to the club of £19 million. All of the cheques that he gave to the club bounced, and he did everything he could to avoid paying the club. So even if you're a gambling club in Mayfair, I suspect that £19 million is still quite a lot. So they entered into negotiations with Mr. U, and they came up with a settlement of around about £16.5 million. And in the end, around about 10 million was outstanding, and so they wanted to bring a claim against Mr. U. It's in the U case that the court set out what a real risk of dissipating assets looks like. So in the case of U versus Les Ambassadeurs Club Limited, the court set out what it thought constituted a real risk of dissipation of assets. Now, I think the court was quite keen to make a distinction between two different fears that the claimant might have. One fear is just a natural fear that someone's going to avoid paying their debts, and they think that somebody is likely to dissipate their assets. And the other, more genuine fear is based on actual events where the defendant is actually taking steps to dissipate their assets. It's not enough for a defendant just to avoid paying the judgment debt. Lots of people want to avoid paying debts, and they'll string it out as long as possible. So just avoiding paying the debt, that's not enough for a freezing order. the thought that somebody might dissipate their assets if they get an adverse order against them, that's also not enough. It's what the court calls fanciful notions. They are not enough for a freezing order. What you need, if you want to get a freezing order, is specific actions, and those turn on the facts and circumstances of any given case. So rather than just say to the court, oh well, of course he's bound to be doing this, what you actually need to say is, look, we have this debt, of course he refuses to pay the debt, but he's not only refusing to pay the debt, he or she is taking deliberate steps to avoid it. We can see that they're moving assets, and we would like that to stop. So that's what you need to show a real risk of dissipation of assets, which is one of the three things you need for a freezing order. The third thing that you need for a freezing order is a strong and arguable case. What is a strong and arguable case? Do you have to go to the court and prove to the court that you would win your case to get your freezing order? No, you don't. But what you do have to show is that you have a case that has genuine prospects of success. Not necessarily more than 50%, not that you're likely to win your case, but that you have a good chance of winning your case. So those are the three things you need to prove. You need to prove assets in the jurisdiction, or else you're going for a worldwide order. You need to show the real risk, that's the lay ambassadeur club versus you case, and you need to show that you have a strong, arguable case. The court will look at all of that, and it will apply what it calls the balance of convenience test, and it will weigh up the inconvenience that will be caused to the defendant by granting the injunction against the possible losses to you by not granting the injunction. It's called the balance of convenience. The court will look at those three criteria and apply the balance of convenience test, and if it works out well for you, you'll get a freezing order. So if you want to bring a claim supported by a freezing order against another party, or you've had a freezing order made against you, or the threat of a freezing order made against you, then we'd love to hear from you. Getting in touch with us is easy. Please go to the website, press on the book a meeting button. That gets you half an hour of our time, absolutely free of charge. Alternatively, drop us an email, get in touch by phone, and we'll call you back. Thanks very much.